This is James Kane for William Woods University, EDU 503, Sports Law. This is a case study presentation for assignment 7.1. I chose case study 8.1 this week. In case study 8.1, Davis versus the Monroe County Board of Education from 1999, the petitioner filed a suit against the Monroe County School District Board of Education. Other defendants from the school district were also named in the suit. The petitioner claimed that her daughter, who was a fifth grader at the time, had been the victim of sexual harassment by another student in her class. Among her claims were monetary and injunctive relief under the Title IX of the Education Amendments Act of 1972. The district court, where the suit was filed, dismissed the petitioner's claim of Title IX discrimination based on the grounds that student-on-student harassment provided no ground for a private cause of action under the Title IX statute. The Court of Appeals for the 11th Circuit affirmed the ruling. Case Study 8.1 considers and researches whether or not private damages can lie against a school board in cases of student-on-student harassment. The petitioner's minor daughter, LaShonda, was allegedly sexually harassed repeatedly by a fifth grade classmate at Hubbard Elementary School, which is a public school in Monroe County, Georgia. The alleged harassment began in 1992 when, according to a petitioner, LaShonda's classmate GF attempted to touch LaShonda's breasts and genital area while making comments such as, "I want to get in bed with you and I want to touch your boobs." According to the complaint, similar incidents occurred again on January 4th and January 20th. LaShonda reported each incident to her mother, the petitioner, and her classroom teacher, Diane Fort. Petitioner contacted Fort and was assured that the incidents were reported to the principal of Hubbard Elementary, Bill Query. According to petitioner, no discipline was handed out to GF, and his behavior continued for several months. Finally, after many months had passed, GF pled guilty to sexual battery when he was charged for his conduct. However, the claims allege that LaShonda had suffered during the months of sexual harassment, and her once high grades dropped because she was unable to study and concentrate on school under such stress. Her suffering culminated in April of 1993 when LaShonda's father discovered a suicide note. Also, it came to the forefront that LaShonda was not GF's only victim. There was a group of girls, including LaShonda, who got together and attempted to talk to Principal Query about GF, and they were allegedly told by school employees that if Query wants you, he will call you, quote unquote. During the many months of GF's harassment, petitioner continued to ask Query why no discipline had been given out for his behavior and what punishment might come in the future. According to the complaint, Query's reply was, quote, "Well, I guess I'll have to threaten him a little harder," unquote. And that, at one point, Query asked petitioner why LaShonda, quote, "was the only one complaining," unquote. As strange as it seems in this day and age with so much training of educators concerning sexual harassment, at the time of the events of this case, the Monroe County Board of Education had not given any instruction to any of its employees on how to respond or handle peer sexual harassment, and they didn't even have a policy on sexual harassment. On May 4th, 1999, petitioner filed suit in the United States District Court for the Middle District of Georgia against the school board, its superintendent, and Principal Query. The complaint said that the school board is a recipient of federal funding for Title IX and that the harassment of her daughter caused her to not perform her studies and school activities, and that the deliberate indifference to the unwelcome sexual acts created an environment for LaShonda that violated Title IX. The defendants then moved to dismiss the complaint under Title IX. The district court granted this motion, claiming that individuals are not liable in cases where federal funded institutions are at fault. Only the institution can be liable. On top of that, the court ruled that Title IX does not provide any basis for the board's liability and that, quote, "the board or any employee of the board did not have any role in the harassment," unquote. Petitioner appealed the district's court decision to dismiss her Title IX claim, and then a panel of the Court of Appeals for the 11th Circuit reversed the ruling. Even though the incident was student on student, the Title IX claimed that the board was liable for a case action under the conclusion, quote, a sexually hostile work environment created by coworkers and tolerated by the employer, and that a sexually hostile work environment created by a fellow student, and then when supervisors and authorities knowingly fail to act and eliminate the harassment can be a claim. The court concluded that petitioner had given facts that was sufficient to support the claim of hostile work environment under the theory that the school knowingly failed to act to eliminate the conduct. The argument of the defendants isn't that they aren't a federal funded institution or that the student-on-student harassment can't rise to the level of discrimination under Title IX. Their argument is that a federally funded institution can't be liable for damages under Title IX under any circumstance for a student-on-student harassment. The defendants also say that Title IX only prescribes misconduct by the actual recipients of the federal funding, not third parties. Searching deeper into the law, the findings do not disagree that the grant recipients are liable under their own misconduct. But the other issue at hand is that a federal funding recipient can in fact be liable for damages when there is student-on-student harassment only when a funding recipient shows deliberate indifference to the incident of student harassment to the point where the indifference causes the student to undergo or makes them vulnerable to Title IX statute. The funded institution must simply respond to the known peer harassment in a manner that's reasonable to not be in violation of Title IX. However, the funded institution does not become liable if deliberate indifference is a cause of Title IX discrimination. So in this case, it's shown that deliberate indifference was a cause of discrimination of LaShonda, and the U.S. Court of Appeals for the 11th Circuit is reversed, and the case is open for further proceedings.